These are the most frequently violated FDCPA rules. First, in the basic definition, section 1692A3. Definition of a consumer as any natural person obligated on or allegedly obligated on a debt. Section 1692A5. Definition of a debt as an obligation for money, goods, insurance, or services for primarily personal, family, or household purposes. Section 1692A6. Definition of a debt collector as collectors, collection agencies, lawyers, forms writers. Contacting third parties. Section 1692B1. Contact of third party failed to identify themselves or failed to state that collector is confirming or correcting location information. Section 1692B2. Contact of third party stated that the consumer owes any debt. Section 1692B3. Contact of third party contacted a person more than once unless requested to do so. Section 1692B4. Contact of third party utilized postcards. Section 1692B5. Contact of third party. Any language or symbol on any envelope or communication indicating debt collection business. Section 1692B6. Contact of third party after knowing the consumer is represented by an attorney. Prohibition communications practices. Section 1692CA1. Contact was made at any unusual time, unusual place, or unusual time or place known to be inconvenient to the consumer before 8 a.m. or after 9 p.m. Section 1692CA2. After it knows the consumer to be represented by an attorney unless attorney consents or is unresponsive. Section 1692CA3. At place of employment when knows that the employer prohibits such communications. Section 1692CB. With anyone except consumer, consumer's attorney, or credit bureau concerning the debt. Section 1692CC. After written notification that consumer refuses to pay debt, or that consumer wants collector to cease communication. Harassment or abuse. Section 1692D. Any conduct the natural consequence of which is to harass, oppress, or abuse any person. Section 1692D1. Used or threatened the use of violence or other criminal means to harm the consumer or his or her property. Section 1692D2. Profane language or other abusive language. Section 1692D3. Published a list of consumers who allegedly refused to pay debts. Section 1692D4. Advertised for sale any debts. Section 1692D5. Caused the phone to ring or engage any person in telephone conversations repeatedly. Section 1692D6. Placed telephone calls without disclosing his or her identity. False or misleading representations in communications. Section 1692E. Any other false, deceptive, or misleading representation or means in connections with the debt collection. Section 1692E1. Affiliated with the United States or any state, including the use of any badge, uniform, or facsimile. Section 1692E2. Character, amount, or legal status of the alleged debt. Section 1692E3. Any individual is an attorney or that the communication is from an attorney. Section 1692C(4). Non-payment of any debt will result in the arrest or imprisonment of any person or seizure, garnishment, or attachment. Section 1692E(5). Threaten to take any action that cannot legally be taken or that is not intended to be taken. Section 1692E(6). Sale or transfer of any interest in the debt will cause the consumer to lose any claim or defense to payment of the debt. Section 1692E(7). Consumer committed any crime or other conduct in order to disgrace the consumer. Section 1692E(8). Threatens or communicates false credit information, including the failure to communicate that a debt is disputed. Section 1692E(9). Represents documents as authorized, issued, or approved by any court, official, or agency of the United States or state. 1692E(10). Any false representation or deceptive means to collect a debt or obtain information about a consumer. Section 1692E(11). Communication failed to contain the mini Miranda warning. This is an attempt to collect a debt. Communication is from a debt collector. 1692E(12). Debt has been turned over to innocent purchase for value. 1692E(13). Documents are legal process when they are not. Section 1692E(14). Any name other than the true name of the debt collector's business. Section 1692E(15). Documents are not legal process forms or do not require action by the consumer. Section 1692E(16). Debt collector operates or is employed by a consumer reporting agency. Unfair practices. Section 1692F. Any unfair or unconscionable means to collect or attempt to collect the alleged debt. Section 1692F(1). Attempt to collect any amount not authorized by the agreement creating the debt or permitted by law. Section 1692F(2). Accepted or solicited postcard check by more than 5 days without 3 business days written notice of intent to deposit. Section 1692F(3). Accepted or solicited post-dated check for purpose of threatening criminal prosecution. Section 1692F(4). Depositing or threatening to deposit a post-dated check prior to actual date on the check. Section 1692F(5). Caused any charges to be made to the consumer, such as collect telephone calls. Section 1692F(6). Taken or threatened to unlawfully repossess or disable the consumer's property. Section 1692F(7). Communicated with the consumer by postcard. Section 1692F(8). Any language or symbol on the envelope that indicates the communication concerns debt collection. Section 1692H. Multiple debts. Section 1692H. Collector must apply payments on multiple debts in order specified by consumer and cannot apply payments to disputed debts. 30-day validation notice. Section 1692G. Failure to send the consumer a 30-day validation notice within 5 days of the initial communication. Section 1692GA(1). Must state amount of debt. Section 1692GA(2). Must state name of creditor to whom debt is owed. Section 1692GA(3). Must state right to dispute within 30 days. Section 1692GA4 must state right to have verification and/or judgment mailed to consumer. Section 1692A5 must state will provide name and address of original creditor if different from current creditor. Section 1692GB, collector must cease collection efforts until debt is validated. Legal actions. Section 1692IA2 brought any legal action in a location other than where contract was signed or where consumer resides. Let's look at the truth about your house loan. It is first important for you to understand that mortgages changed significantly after much banking deregulation in the 90s, moving onward to 2001 with the advent of mortgage securitization. No longer did a bank make a loan to a homeowner with the intent to hold that loan as an asset in a portfolio. With mortgage securitization, loans were pulled together in bundles and blended together to make a more uniform performance to the pool's investors. For example, if you were to take your mortgage and that of 1,000 other people and blend them together in a blender on top speed, you would end up with an unidentifiable toxic mess of assets that you can no longer determine the individual details of any longer. Instead, there is a mortgage-backed security that can be bought and sold separately from the individual mortgage itself. The payments of this toxic mortgage milkshake are then assigned to a servicer that acts as nothing more than a collection agent. At the same time the servicer accepts this agreement for receivables, they accept a separate agreement to pay out liabilities to different unidentified parties. The effect is a mortgage that cannot be traced to its true owner and holder in due course. An additional effect is that the loan can no longer be distinguishable from the others in the pool, leaving permanently unknown the location of the original promissory note. Once securitized, the bits and pieces of the loan can then be traded, sold, insured against, and in the process making it near impossible for anyone, including the homeowner, to ever determine who owns the debt and who is authorized to negotiate that debt and its terms with the homeowner. This is why loan modifications that benefit the homeowner and keep them in the home are impossible. Your mortgage currently does not reflect the terms you originally signed and agreed to. Due to securitization, the terms of your loan as being enforced currently have been modified without your permission. In many cases, homeowners have been charged fees not authorized by the original terms of the mortgage. The party you pay your payments to more than likely does not own your note. When a loan is securitized, the note is destroyed and the deed of trust is given to another party. This is called bifurcation. The payments are assigned to a third-party servicer, and this is who you make your payments to. Your original documents have more than likely been destroyed intentionally or of necessity. In the digital age that we live in, storage fees for thousands of physical mortgage documents that can be thousands of pages each can be expensive when compared to digital storage. Due to this fact, many storage documents are scanned and destroyed by the original lender. Other times they are lost or destroyed intentionally where parties have collected on claims of insurance policies in effect to cover against such losses. Most mortgage documents are just not available. Original documents are required in foreclosure, a sole method to verify validity and authenticity. Courts in federal and state jurisdictions have upheld that original documents must be provided in order to validate and authenticate the claims when disputed by any of the parties involved. Every time a mortgage is transferred, documents are required, same as a car, house, or any other asset. In some cases, original documents are available to confirm the existence of the debt. However, if the debt was sold, transferred, or collateralized with other pools of loans, it must be determined if there are any other claims or parties that may have claims prior to any foreclosure being complete. There must be a proper chain of ownership in order to confirm the claims of the parties involved. There exists rampant fraud in the bubbles of real estate, mortgage, and Wall Street securities. From real estate valuation to sales terms, mortgage terms, and documentation to underwriting, there are countless examples of negligence, fraud, deceptive practices, predatory lending, and many other crimes that have equally countless victims. Many of these victims are seemingly unaware of these crimes and are losing their homes en masse. Wall Street has only been the conduit for the real estate industry bubble created from 2001 to 2010. The courts have upheld that a deed of trust and a mortgage note cannot be traded or sold separately. This is bifurcation. Federal and state courts have upheld that the power of sale cannot be conferred separately from the ownership of the debt itself. Most foreclosures are conducted by a trustee or substitute trustee who has been instructed to do so by parties that do not own the note or the debt itself. This is fraud upon the court, not to mention the injustice on the victims. Most mortgage notes have been sold or traded separately from their deed of trust with power of sale. This is true for a far majority of mortgage loans in the United States. If your mortgage happens to be one of those that has been held as a portfolio loan and has not been securitized or sold, there are many other claims that you may have to defend against foreclosure. Originating lenders and brokers of mortgages are out of business, leaving no trail of documents to verify. It is true, as many know, that upon the bursting of this bubble in the summer of 2007, more than 300 lenders shut their doors quickly over a 3-month period, destroying their records, documents, and paper trails. In many cases, this leaves a cloud of doubt over the title and the true ownership of the debt that should be disputed for clarification. One of the biggest signs in any of the deeds is when the deed includes MERS as an assignee or a beneficiary or a nominee. That mention should set off anyone's alarm in their mind. Most banks and parties conducting foreclosures are not authorized by law to do so and can be beaten at their own game by disputing the validity of the debt and then turning the whole matter around and suing them in federal and state court. You may even apply the FDCPA in many of their actions and violations.